Welcome to Coverage and Clarity with Jacques, the podcast where we break down protection, planning, and peace of mind so you can make confident decisions for the people who matter most.
Welcome back to another edition of Coverage and Clarity with Jacques. Now, today, you're going to want to take out a pen and paper to take notes on today's topic. We're going to talk about something very important, something that every adult should have, but many put off, and that is the last will and testament. Now, no matter your age, your net worth, a last will and testament ensures your wishes are followed, protects your family, and reduces stress and the conflict that occurs when you're gone. Now, I've been working with clients for over 28 years. In addition to not having enough life insurance or any at all, what I find even more is people who do not have a last will and testament in place. Now, a last will and testament is a legal document that states how and what your assets are and that you will distribute when you die. Now, it names who gets what you leave behind, appoints an executor, carries out your instructions, names the guardians for any minor children that are in your care, whether it be your own children, grandchildren, foster children, etc. Now, the last will and testament is different from a trust, a power of attorney, or even an advanced healthcare directive. Now, all those documents handle different things while you're alive or provide a different way to transfer your assets. Bottom line, a last will and testament is a foundation in everyone's estate plan. Now, many people think that estate plans are only for the people who are rich, who have a lot of money. Everyone needs an estate plan because what people do not realize, if you die and do not have a will in place, the state will decide who gets what for you. Now, this could lead to delays in your transference of your items to your families, any inheritance that you may have, whether it be from insurance, property that you're transferring, etc., are all tied. So this is why you want to make sure you have a last will and testament in place. So when you have a last will and testament in place, all your wishes are clear. No one could say this is what you did or did not want to have happen. It's clearly stated such and such person will get what I'm leaving for them. Now, your loved one avoids any unnecessary legal confusion. Because, as I said, if you don't have one, the state will appoint not only the guardianship of any children you may have who are minors, but also who gets what of your property. And if you try to sell a property and you don't have a will in place, that could delay the process even longer, thereby causing more money for the attorneys. Now, you can name the guardians for any minor children that were in your care. So, as I mentioned, whether it be your own children, grandchildren, foster children, nieces or nephews in your care, you know specifically who the children go to, and it's not left up to the courts or someone else to say who the children will go to. So, what this will do overall is reduce the cost and time of administering your estate. So now everything runs smoothly. Once a person passes, at least all their financials and anything that they wanted is all taken care of. Now, when you do not have a last will and testament in place, your state's intestacy laws decide who inherits your possessions. Now, this could lead to the following issues: family disputes and contested inheritance. People say this should have been theirs or not theirs, or why did such and such person get whatever it was that you left? Unintended heirs could receive assets. People you did not intend to leave anything to may be able to get stuff because of a court decision, another person's decision, or whatever the case is. Court battles over guardianship for children. The last thing you want to do after you're gone is to have your children not know who they're going to be with. Delays make the legal cost so much more. So these are all the stuff that you prevent by having a last will and testament in place. Now, because of all this that I've seen over the years, I provide both a family data guide and a last will and testament to all my clients. Now, before I go into all this to show you what I do, if anybody has any questions on the family data guide, final expense coverage, last will and testament, or just getting insurance in general, what you could do is contact me for more information right here at 631-594-8118. Once again, that's 631-594-8118. Now, here are the specifics that I found on both the family data guide, and the last will and testament. What I'm going to do is break it down for you line by line so that you know exactly what's there. Now, as I mentioned, over the years of doing this, I've seen too much go on. So what I created is a form, and as I mentioned, I give it out to all my clients called a family data guide. Now, on here, the top part of the form has the vital statistics and historical data for the individual. Who is the individual? Their phone number, the address. If they're married, who's the spouse? Here's one thing a lot of people do not remember or know. What is the spouse's social security number? Now, this form, as I said, is given by you to whoever is going to take care of your estate later on. So whoever it is, you want to make sure that not only do you trust them with the information, but that you know they're going to take care of it. Now, I will tell you at the end how to make sure this form becomes legal. Okay. So by having that, you're going to include all that information. What's the mother's maiden name, not only for you, but for your spouse, so that you each have that information out there so that when the time comes, there's no questioning who do I go to, where do I get this information? It's all clearly listed. Now, for all the veterans out there, first of all, I want to first thank you for your service because without you, we would not be sitting here talking about this or any other subject at the moment. But in regard to the form that I created, on the veteran section, you're going to put down everything. What branch of service were you in? Your enrollment, your exit dates, etc. Because as you know, with veterans, they get special treatments at funerals. Whether it be right here in New York, for instance, the Calverton Cemetery, one of the national cemeteries for the veterans, or other benefits by being a veteran of the United States. So all that information you want clearly listed there so that people know everything from the rank, serial number, branch of government, etc. that you fought in. Now, the spouse's vital statistics and historical data is also listed on here. You want to make sure that you know all that information. Where were they born? Mother's maiden name, as I already mentioned before. So these are all stuff that's listed on there. Now, when it comes time to be notified of a person's passing, you want to list at least three people on here. Because as you would normally assume, the spouse or the adult children will take care of everything. But at the time of passing, not everyone's in the right frame of mind. You want to have at least one to two people that you could definitely trust to take care of stuff, and another one who's in charge of all the arrangements. So this way, it's not people are not crossing who does what for the arrangements. Everyone knows their parts. So now you clearly list who these people are. What's their relationship to you? So now it's all in writing. Now, going back to today's topic, the last will and testament, many people think that they have to go to an attorney, spend thousands of dollars to do so. Well, the last will and testament could either be a form that you got from the attorney, where of course you spend the money, or you could get it on a boilerplate, such as what I provide, stuff that you could get at online, showing all the items that you want to leave behind and everything else. What's most important when you have a last will and testament and it's completed is making sure it's signed, dated, and notarized. That's the most important thing, have it being notarized. Now, whoever your executor is, the executor, as I mentioned, will be the person taking care of everything for you. They're going to file it with the courts after you're gone. Now, many people think that you must have a will and testament before you're gone. Yes, that's when you personally fill it out, but it doesn't take effect until after a person passes. So it's at that time it gets filed with the courts so that everything's taken care of for them and the family. Now, in the last will and testament, I will go through specifically what each sections are. So I'll keep that aside for the moment. Now, here's something else a lot of people don't think about. The estates has things such as any bank accounts that's out there, any old checks from work that was not cashed. What people don't realize, if this is not cash or not acknowledged that the person had it, or remains dormant because it wasn't an account, the secret account that a lot of people say they want to have. If it's secret, of course, people are not going to know it's there. What happens if it doesn't get claimed? It goes to the state. Now, you work too hard for your money, whether it be $1 or $1 million that's there. You want to make sure all your money is accounted for and left to your heirs. So on the form that I provide to my clients, they list any bank accounts that they have, both the working bank account, which is the one they pay their bills with, and any other savings account. Maybe it's like a holiday fund, another savings for emergencies, etc. It's all listed with which bank it is and the policy number, and of course the amount, just so that the family knows approximately how much is in there. The amount, of course, is going to change from day to day, but at least you know what you're leaving. Same goes for any life insurance policies you have outside of what's yours, what's portable and permanent. Permanent being that is there for life, and portable because it's yours, it's not part of your company's coverage. But even with your company's coverage, you want to list what you have, how much is in there, and how much the family would get in the event you're no longer there while you're working. But the whole purpose of having permanent personal coverage is because we hope that you're going to be around much longer than just at the time that you're on your job. So this is the reason why you want to have that. Now, when it comes down to the funeral arrangements, you want to list where you want to be buried. What type of service do you want? Do you want a church service, a funeral home service, a graveyard site service? What cemetery you want to be buried at? Do you want to be cremated? Do you want to be buried normally? For many people who may have come from another country or have relatives in other places, whether it be another state or another country, do you want to be shipped to another location after your passing? These are all information that needs to be listed on the form so that there's no questioning when the time comes. And as I mentioned, what's important is that you get it signed, dated, and then have it there with the person that you could trust to file it. Now, of course, as time goes on, things will change. From the earlier years when you have little children to later on when they're grown, maybe you got married, maybe you got remarried, etc. There's going to be changes on here. So this is why, as changes occur, new children, new grandchildren that you want to leave things to, etc., you want to update this form. Once this form is updated, the last copy that's there is what gets filed. So what I always tell people, as time changes in life, from having little children to grown children to then having grandchildren, update this form. Do so every 5, 10 years or so to make sure that everything's up to date. Whatever it happens, you want to make sure that the final copy is what's there that gets filed, which will go with your wishes. Now, this in turn ties to the last will and testament that I mentioned earlier. Now, the last will and testament is basically filed by anybody age 18 or over. You want to make sure that the person's in the right state of mind, that they're not um, taking any alcohol or drugs. They know what's there and it was not done in duress, meaning that they were not forced to do it. You want to have this done freely because this is a legal document, remember. So on there, what you're going to do at the very top, you're going to put the name of the testator. The testator, of course, is the person who's doing the last will and testament, which is basically you as the individual. So you're going to list yourself on there. Where do you live? What county, what country, etc. So it's all listed there. And as it says, being of sound mind and memory, meaning that they were not forced. They knew exactly what they were doing when they filed this together. Okay. Now, for those who are married, you want to list your spouse on there because remember, the spouse usually takes priority over anything that you leave. So until you start listing specifically who else will get stuff, the spouse is the primary person. So you want to list who your spouse is. Now, on there, you also want to list your children. You want to make it very specific. What are the children's names? What are their date of births? By having this on the form, no one could ever say you forgot somebody or you didn't have somebody. Now, as I mentioned before, if you have more children after this form is filled, you want to get it updated. So what a lot of people put is per stirrups, meaning that all the children of the marriage is automatically included. But you want to be more specific when you do this so that as time goes on, you have more children, you update the form and you list them specifically so that they're all on the form so people know specifically who are the children that you're referring to. Now, in section two of this, you go through all the payments, any debts, any taxes, or other expenses that must be fulfilled by you. So by having it here, it's all clearly listed what they are, who gets them, and how much. Because remember, upon a person's passing, their estate still has to pay off the debts that's owed, whether it be credit cards, bills, doctor bills, etc. Anything like that has to be taken care of. So you want to make sure all that is clearly listed. The next section, which is section 3 of the last will and testament, is what you're leaving specifically. Here, you're going to list the individuals you want to leave things to, who the beneficiaries are, and be very specific. Where do they live? Your aunt in Arizona, your cousin in Florida. So now they know specifically who it is because, as you know, many people have a common name that could be the same. So you're listing specifically who it is so that no one else comes in and takes what you're leaving who may have a similar name. So now you're going to list who it is, where they live, their relationship to you. That's all clearly listed on the form. Anything you want to leave to charity. So whether it be for a church, a charity, an organization, you're going to list who it is, the name of the charity, the location of the charity, and how much you want to leave. A lot of people may leave this as part of their life insurance proceeds, that it'll go to their specific church or congregation. It'll go to a specific fund that they were adamant about throughout their life. So with this, it's all clearly listed, and that is when the payments are made. What is approved for them will go to that particular person that's there. Now remember, that's provided the spouse does not survive you because the spouse takes primary coverage of the beneficiaries of what goes there. But if the spouse is not there, now it could now be left to charities or other people. Because remember, the one thing with these contracts, the spouse gets whatever go is left by the individual first, and then it gets distributed to everybody else. Now, today's day and age, you have digital assets, whether it be anything from Bitcoins, um, digital accounts, etc. You want to list those also. So outside of the spouse not being there, now you can list who those will go to. So this is where everything has to be clearly listed on here. This is why I always tell people make sure you know exactly what you're leaving, who is going to, and that you're able to fill this out. Now, the next part, which a lot of people don't think about, are who gets their pet. Now, remember, a pet is like a family member. You want to make sure that if you're no longer there, or your spouse is no longer there, also, who would get your pet? You want to make sure that the pet goes to somebody who's going to care for it as much as you care for them, not going to a shelter or out on the streets or whatever the case is. You want to make sure they're fully protected. So now you're going to list in the event you're no longer there, who's going to be the caregiver for your pets. Now, any other personal effects is the next section. So now you list specifically what you're leaving to who. After that becomes the properties. Like I said, if it's not the spouse that they're leaving to, who's going to get it? Is it going to be the children? And if so, what percentage of them will get it? So now you know exactly whether it be one property or multiple properties, who gets what, and at what percentage. If you want to share it between 4 people, as an example, share between 2 or give it all to one, it's all clearly listed. So this is where your wishes come out in terms of the final last will and testament. Contingent beneficiaries. Now, what does that mean? If the person you're leaving to is no longer around and they pass before you pass, who will get it in place of them if they're no longer around? So you always want to think of the opposite the future on that as well. So it's not just who you're leaving things to, but who's the backup person to get it in place in case they're not there. Now, for instance, it may be to a child, and if the child should predecease you, it'll go to their children. So now you know it stays within the line, or maybe a totally different person that will be there if the person should predecease you. But these are all reasons why you want to have everything clearly listed. Now, to me, the most important part here is who's your personal representative, known as your executor. Now, he or she will be the one who will deal with the courts, will deal with the attorneys, will deal with filing the paperwork to make sure that your will is filed with the state upon your passing. Now, he and she will have the personal representation, what they call POA, power of attorney. So they'll be the executive of the state. They will act on your behalf in your best interest of what you want to have done. So they will take care of everything that you would normally take care of yourself. Now, the next section, which is section 6 of your last will and testament, if you're just doing a standard one, who's going to get the minor children? As I mentioned earlier, if you have any children, foster children, grandchildren, nieces, nephews, other children that were in your care who are under age 18 upon your passing, who do they go to? You want to make sure that a guardian is appointed for each and every single child that's there. It's not just a person you're going to say takes care of whatever number of children it is, whether it be two, three, four, five, or more, as an example. You're not going to just put that. For each child, you want to have a specific guardian for his or her care. Now, any special directives? Do you have anything that needs to be taken care of? Could it be a collection that you may have? Could be a car collection, a baseball collection, or other things that interest you. You want to make sure who gets those directives. If you're a business owner, who takes over the business upon your passing? What happens to the business? Does the business close upon your passing? This is where all special directives are put in writing so that everyone knows what happens upon your passing. Now, you want to make sure you have a minimum of two witnesses. Now, these witnesses are people who are not related to you, are not receiving anything from your proceeds of what you're leaving to the state, so they're totally unbiased. With the witnesses is going to list who they are, where they live, and their contact information. So now they're going to witness you signing your will and testament, and now no one could ever say you did or did not do this. They're going to be the backup person to make sure that everything that you did was legitimate and done correctly. Now, after all this is done, it gets signed and dated and stamped by a notary. Now, remember, this is what makes it legal. And once a notary takes care of it, it becomes a legal document. So just like the other certificate that I mentioned earlier with the family information that I pass out, you want to make sure that this is notarized as well. Because once it's notarized, it's now a legal document. The next step, as I said, is to get it filed with the courts. So once it's filed with the courts, it gets taken care of, and now all your assets are totally transferred over to your family members, organizations, or anything else that you want listed there. So as you can see, this is why I'm very adamant about what I do, because over the years, I've seen too many people not do this. I've had clients who had their home held up in sales because it was still in the process of being probated. Probated is when a court attaches, let's say, for instance, they want to decide who gets it, when it gets sold, how much it gets sold, etc. So in this process, that takes time. And as you know, when it comes to the courts, the longer things wait, the more expenses the family will have to spend. So this is why you want to make sure everything's clearly listed and that there's no information that's there that's left untouched. So as I said, and more important than just having the life insurance in place, you want to see how everything that you leave in there for your family gets taken care of. This is where your will comes into place. So make sure you have one there. Now remember, I work nationwide. So if you want any answers to what I discussed today, or if you want me to help you with anything from the will to life insurance to the final expense coverage for yourself, remember, feel free to give me a call. You can call me here at the studio. The number, once again, is 631-594-8118. That's 631-594-8118. Now remember, this is Coverage and Clarity with Jacques, where protection meets understanding. Until next time.